who is the Edwin B. Parker Professor of Comparative Law and Director of the Center on Global Legal Transformation at Columbia Law School. She's the author of many books. I've recently looked at her book on corporate governance, many articles on regulation, but it's the book, the most recent book, as far as I'm aware, The Code of Capital, How the Law Creates Wealth and Inequality, which is what many of it's being read here, Katharina, and so we thought we should have the opportunity to hear you explain and your argument. I also want to welcome all our participants from the law school, the CLM faculty, the university, our public life, and I understand many international colleagues are joining this conversation as well. We're very delighted about that. So inequality is undoubtedly the central question of our time and raises many questions about injustice in our societies, about the feasibility of democratic self-government. And it's a question that must now be frontally engaged. In South Africa, lawyers, progressive lawyers who are interested in this question have tended to be public lawyers, to be less interested, if you like, in private law. So Professor Pistor's thesis that law, through its coding practices, and main institutions of private law, contract, intellectual property, property law, help, on the one hand, to create wealth, but they also play a role in explaining growing inequalities. So her thesis will be a great challenge, I think, to South African lawyers, but will also be of interest, I think, to non-lawyers, because at the very least, it should encourage non-lawyers to take the law and its impacts, whether positive, ameliorative, or negative in this way, seriously. With that, I'm delighted to invite Professor Pistor to deliver her observations.
Thank you very much for the kind introduction. So let me see whether I can share my screen with you. That's fine too, but I want to share my screen. Whoops. How do I do that? So let me just make this share. You still cannot see my screen, huh? I'm pressing on share. And for some reasons, can you see my, no, you can't see my PowerPoints. No, I'm not sure why it does not do this. So I'm not trying.
Katharina, would you like me to perhaps ask Magda to upload your slides?
Perhaps, maybe she can do it and I can just walk her through it. For some reasons, I'm pressing on the little dot here to say share screen, but it doesn't do it right now. Let's see. Yeah, why don't you ask her to do this? And I'll try in the meantime, see what I can get it
why don't
up.
you ask everyone to mute their videos as well, because we're getting feedback. Yeah.
Yeah.
Okay. So you put it up now, right? Okay, so why don't we go to the next slide? Okay, so I just wanted to make clear at the outset that I'm of course not the first one who talks about inequality and the law. And of course there are many different facets of how law contributes to inequality. And I just thought I'd start the discussion by throwing out a couple of quotes. They're just random quotes, you can find so many more, but one I picked up on National Public Radio yesterday here in the United States. I'm sure you have been following our current political predicament and the mass demonstrations for Black Lives Matter. And Robin DiAngelo said on the radio yesterday, racism is what happens when you back one group's racial bias with legal authority and institutional control. So this question of legal authority to legitimate inequality is central, also central, I think, in our debates about racism. Of course, talking to colleagues in South Africa, that is nothing new to you, but I just wanted to bring that perspective to the table as well. Another, of course, very famous quote by Anatole France is, "The law in its majestic equality forbids rich and poor alike to sleep under bridges, to beg in the streets, and to steal their bread." And then here's another by John Taylor, who says, "There are two modes of invading private property. The first, by which the poor plunder the rich, is sudden and violent. The second, by which the rich plunder the poor, is slow and legal." Can I have the next slide, please? The one quote that I used to motivate my book is a quote by Bernard Rudden, and that goes, I think, to the mechanisms of what Taylor describes, sort of the rich plunder the poor in a process that is both slow and legal. And Bernard Rudden is a legal historian. He taught at Oxford for many years. He also taught Soviet law. And he wrote in an article in 1994, the traditional concepts of the common law, somehow you're, okay, the traditional concepts of the common law of property were created for and by the ruling classes at a time when the bulk of their capital was land. Nowadays, the great wealth lies in stocks, shares, bonds, etc. In terms of legal theory and technique, however, there has been profound, if little discussed, evolution by which the concepts originally devised for real property have been detached from their original object, only to survive and flourish as a means of handling abstract value. The feudal calculus lives and breeds, but its habitat is wealth, not land. So that's really, I think, captures what I'm trying to do in this book and really has motivated this book in a great deal. Can I have the next slide, please? So if I just abstract from the couple of quotes I gave you, you can basically say law contributes to inequality in multiple ways. One, by making inequality an explicit feature of a legal order. And we know such orders. Feudalism, colonialism, apartheid are legal orders that sanction inequality along multiple dimensions. Then we have legal orders that claim to have formal legal equality, but pay little or no regard to material inequalities. And that's a feature of many modern constitutional orders. There's, of course, a variation. I'm quite aware of South Africa's constitution that gives positive rights, not only negative rights. But as you know, in the US, at least the federal constitution is very much committed to a legal order that gives individuals negative rights against the states, but not positive rights. And so inequalities are a part of at least not necessarily of concern for a legal order that is primarily concerned with formal rights. Now, the issue that I'm most concerned with is the third one here, is state-sanctioned private ordering. So it's private ordering that is state-sanctioned and where people have differentiated access to the law. That, I argue in the book, basically is an essential feature of our capitalist economic and capitalist legal orders. There are other aspects that you can add on to any of the three characterizations I gave you above, and that's, of course, taxation I would say, is a supplement, as would be fees, as would be social programs. But I'm just mentioning taxation here because Thomas Piketty and Gabriel Zuckman, of course, have made this point that most of our inequality relates to taxation, which has become if not regressive, it certainly is no longer progressive in this country. Zuckman argues in his recent book with Emmanuel says that it's the first time that actually the super rich pay less taxes than do the poor in this country. So I think this is also an important aspect. I would say it's basically a supplement, because tax basically gives you a tool to address inequalities that are created, however, in other ways. And I want to go to the sources, to the roots, to the of inequality, and that's why I look at the private law dimensions of inequality. Next slide, please. So when you think about the role of law, you also have to think about the state. And I do discuss this a little bit in the book. I think there is still at least an article, if not another book, to be written on a theory of the state that is that picks up on the themes that I develop in the book. So just very simplistically, and folks who are political scientists or constitutional theorists will take issue with this, but let me just sort of say this in a very simple way. I basically conceive of the state as the institutionalization of coercive or centralized coercive powers, and they can be institutionalized in different ways. Most people who think about legal ordering, who are not lawyers, think about legal ordering as something that the state does vis-a-vis its citizens or other people on its territory. Those that are concerned with constitutional issues or human rights also think about the kind of rights that citizens or individuals might have vis-a-vis a powerful state. These are the negative rights, sometimes the positive rights I mentioned before. And then, however, there is, of course, a lot of legal ordering in a horizontal fashion where private parties order each their relations with other private parties using law. Every contract is a legal device, and implicit in using a contract that is legally sanctioned is the ability to enforce, thereby to make use of the coercive powers of the state if need be. It doesn't mean that you always use these coercive powers, but you have the option to. And one core argument that I make in the book is that we wouldn't have been able to scale social economic orders to either national or even global legal orders without the help of law, which is basically the ability to somehow commit credibly that a claim will be enforced if necessary by some court of law. Doesn't have to be the court in the country where the contract is made or the assets are located. It doesn't have to be the country of the law of the parties to the contract. It could be a different state and a different legal system. But the core is here that we basically are relying on coercive enforceability. Now that's true for single legal orders. In multiple legal orders, it gets a little bit more complex, and I will talk about this later on. But in multiple legal orders, of course, we have relations between states with international treaties. We also have relations between a host state and a foreign private agents that basically gets us to the question under what conditions private agents can use either state A's laws or their own state B's laws to conduct business in state A. And then, of course, we have legal constructs such as investment treaties or trade treaties that give, whereby states, sovereign states, give private agents from their respective territories rights vis-a-vis the other state. Next slide, please. That's just quickly, it's just a restatement of this one. What I want to say in this book, I'm focusing mostly on the citizen-citizens relationship and basically private legal ordering, horizontal legal ordering. And when I talk about multiple legal orders, I'm also thinking about how private agents can invoke the law of their choice to enforce the rights that they wish to enforce. I do, however, also talk in the chapter on globalization about bilateral investment treaties, or in the case that I use is mostly devoted to NAFTA, but that's the same thing. So whereby basically sovereign states grant private agents from each other's territory specific rights against themselves. Next slide, please. Okay, so this is really the core of the argument I make in this book, and so it raises the fundamental question again: what is capital? And I'm arguing, and I'm following others. Piketty has or defined capital in a similar way. I'm basically saying capital is a wealth-generating asset, but you have to think about where the wealth generation capacity comes from. And it comes from, of course, social relations, as Karl Marx would have argued, but I want to specify that the social relations of a particular kind, there are in law and they're imbued in the institutions of private law, over which private parties have a lot of not power, but they can use them, they can avail themselves of these institutions. Yeah, this is the slide I'd like. Okay, so when I'm talking about capital in the book, I'm basically saying a capital asset is different from an ordinary object, claim, or promise. So just give me any object, claim, or promise to future payment, or an idea that would be intellectual property rights. And with the right legal coding, I will flip them into a wealth generating or capital asset. And the core features that such an asset receives by coding are 3 at least of the 4 I'm listing here. So let me say a few words about each one of them. The first is priority, which means that we rank claims against other claims. Some have stronger rights than others, right? So property rights give an owner the right to control that asset, to largely exclude others from its use. I like to say that bankruptcy is the acid test to see what kind of private rights people have. And in bankruptcy, somebody who owns an asset that is in the possession of the debtor can pull it out, and no creditor can prevent him or her from doing so. Other property-like claims, such as collateral law, also give creditors a stronger claim. They can separate an asset they want to enforce against because they have a collateral or security interest in that asset. So private legal ordering allows private parties to rank their claims vis-a-vis one another. The second important dimension of wealth creation is durability. And in my stories, really durability does most of the work. And that's kind of important because it, I think, speaks to many reform programs that the World Bank has delivered in the past. So it's basically privatization, property rights, creation, etc. What I'm basically saying is just ranking, which is what you do when you create property rights, is not enough. In order to create wealth, you want to make sure that your rights extend in time, that you can incubate your claims over time. And that basically means that you get protection against creditors if you need it. And the kind of protection, for example, that English landlords used once they had secured their property rights in the enclosure movement, they entailed their land so that the creditors couldn't take away the land. And they did this basically by creating trust-like structures and arguing that the owner of the land wasn't really the owner, but just the life tenant that held the land for future generations, which created a legal barrier for creditors to enforce against the land. That kind of system was in place in England until the very end of the 19th century. It created basically the incubation conditions for private wealth to be generated. Of course, it was also inefficient at some level because you reach the point eventually, but just eventually, where creditors wish to enforce and they can't enforce, and they finally cut you off from the credit line. And in England, this meant that in the 1870s, you had a huge implosion, a depression in agriculture. And then finally, in 1881, you had a new law whereby basically the Land Settlement and the Land Conveyance Act basically said, we will treat the life tenant as an owner, and creditors can enforce. And yes, all your assets can go on the auction block. For the family mansion, you might still need approval by a court, but in principle, all the assets can go on the auction block. I'm insisting on this not only because of historical reasons for England, but I'm insisting on this when, again, when we think about titling programs that the World Bank and other organizations have promoted. The issue here is when you give people title and they are supposed to use it in De Soto's world to actually monetize their assets so they can get credit and build a business, etc. If you do not protect them against future crises, especially crises over which they have no control, this will not do much to them because they will be simply subject to the downturns in business cycles and they will lose everything. So if you think about creating wealth through assets, you also have to think about durability. And of course, think about its abuse. It was clear that the English landlords have abused this for decades, but they got away because there was no better game in town, essentially. But durability is really important. Extend your protections in time and against multiple parties, which brings me to the third critical aspect of of capital, which is universality, which means that we have these claims, these legally protected claims, not only against our immediate contracting parties, but we have these claims against the world, ergo omnes, as the lawyers like to say. So it's basically expanding these rights in space. The state will enforce your property right against third parties that don't know about your property rights, that were not part of the bargain at the beginning, but that's the point, right? These are universally protected rights. In the civil law tradition, folks would say this is property rights as an absolute rights. But many other rights are in some ways. Contracts are also protected against third-party interference by tort, for example. The point is that the legal system recognizes certain types of interest as enforceable not only between the two parties that entered a contract with one another, but against others as well. The fourth element I call convertibility, which is different from assignability or just tradability. It is basically an option to convert, to flip an asset into a safer one, ideally on demand, but at least in the hope of a benevolent, benign counterparty that will take these assets. Convertibility is essentially how financial assets attain durability. So for financial assets, you don't want to hold them together for ages, but you want to be able to reposition your claims, to remix your portfolio in different times. And especially when there is a crisis and everybody's heading for the exit, what you want is to convert your private asset that generates wealth into state-issued legal tender, which is the only financial asset that holds its nominal value. And in times of crisis, it's absolutely critical to have protection of the nominal value because everything else can go down the drain. So convertibility is, as I suggested, really it's the way in which you can lock in past gains of financial assets in times of crisis, which gives the past gains durability, right? So the two are just similar, different mechanisms to attain similar outcome. Next slide, please. I think you're going to reverse. Okay, so in the book, I'm basically saying there are a handful plus one, maybe 6 legal modules, legal elements that you can use to code capital. These are not the only ones, so many lawyers have pointed out to me that you can achieve similar results and in other way as well. Of course, you can also use regulation sometimes, but the point for me was to show how private law institutions have been used in the past in a fairly comparative fashion to show how capital is coded as law. So the core private law institutions that I'm discussing is property law. That's property in land, in other movable objects. It's also property rights in intellectual property, which is one of the most valuable asset class today. Collateral law is a subclass of property law, which basically gives you priority rights over other creditors, and that's always relevant, particularly in times of bankruptcy. But in our financial system that has become so much a market-based, parallel or shadow banking system, collateral law and repo transactions are absolutely key for sustaining that system. The good old common law trust is a central feature. I sometimes like to say it's one of the most ingenious legal institutions and ever invented, because it gives you the ability to create property rights relations in contract. And that's something that the civil law lawyers dislike because it breaches the boundaries between property rights and contract law, between absolute rights and relative rights. But the trust law does precisely that, and that's why it's so ingenious. You can basically shield assets against third parties by putting them into a trust and appointing a trustee and making them available to a beneficiary at some point in time. Trust law was key for the entailment of land. Basically, the basic idea of trust was key for the entailment of land in English history, and trust law is absolutely central for securitization, derivatives, and other elements of our shadow banking system today as well. Corporate law does some things similarly to trust law in the sense that we shield assets, we pool assets together behind a legal veil, which are the assets that now are owned by the corporation. So we have what Henry Hansman and Renier Kragman in their work have called, we have asset shielding, which comes in two forms. It comes as owner shielding and entity shielding. Owner shielding is basically what we know as limited liability. And a shareholder of a corporation or limited liability company will not have to put bad money after good money, will not be responsible for obligations of the corporation that it cannot meet. But the flip side of that, entity shielding, is also really important, which basically means that the creditors of the shareholders cannot put their hands on the assets of the corporation. They would have to seize the share of the shareholder, and that gives that shareholder a voting right to liquidate the company, but not more than that. The corporation owns its own asset. Also, this, of course, a critical invention in the history of law that was important for the evolution of capitalism. Bankruptcy law is somehow a hybrid between sort of private law, over which we have a lot of control, that is malleable in the hands of lawyers, because bankruptcy law is mandatory. But bankruptcy law establishes its own priority rules, and therefore I put it in here. It's quite important to think about whether or not and under what conditions debtor can actually get protection in bankruptcy first, but also the kind of rights the creditors have against not only the debtor, but also against one another. It is where we order and rank claims. It is the acid test, as I said earlier, of the private law claims that we might have. And then last but not least, contract law is of course critical. But contract law in its essence is really a bilateral contract between two parties, but it can mimic many of the aspects of property law and collateral law nowadays, especially in the world of digital coding, where we have reduced transaction costs so much, where we can make binding commitments basically in the digital code, that we don't have to rely as much on property law as we did in our old legal system anymore. Okay, next slide, please. Okay, so what I basically do in the book then, and we don't have enough time to walk you through the different cases. I'm would be really happy in the Q&A later on to talk about specific cases. I'll just illustrate in this slide a little bit what I'm doing. I'm basically using different types of assets, land, firms, debt, and know-how, and show how the different legal modules of the code have been used to protect these different assets, to code them as capital. So in the chapter on land, I talk about the enclosure movement in England, of course, in the 16th century and beyond. But I also talk about the Maya in Belize that are using a claim first in the Inter-American Human Rights Commission and then in their own Supreme Court to make the claim that there are centuries old collective use practices in Belize actually should be recognized as property rights. So that case is interesting because it shows you that actually we can define property rights in many different ways, and you can actually recognize collective use rights as a property right if you want to, which the Belize court did under the constitution, under relatively open-ended provisions of that constitution. The case also illustrates, however, that the state is not necessarily throwing its coercive powers behind just any property rights. So in that case, the government of Belize was on the other side of the dispute and did not really recognize or enforce the case in the end, because it continued to hand out licenses to mine the lands of the Maya in contradiction to that court ruling. So it's sort of this ambivalence between when actually does the state then live up to its commitment of enforcing property rights is an interesting political economy question that this issue raises. For firms, I'm using an institutional autopsy of Lehman Brothers, the big institutional, the big investment bank that failed in 2008 in that crisis. But I'm basically trying to tell a different story from the one that is usually being told, namely the legal story. Lehman basically being an entity that is organized as a unitary global bank, and yet is organized in over 200 officially recognized subsidiaries and many other legal entities. But interestingly, it's not that they're all spread out around the globe, but we have about 60 Lehman entities were incorporated in the state of Delaware, 34 in England, 30 some in the Cayman Island. So I use this structure to show how the corporate form is used to shield assets, right, against different groups of creditors, and to channel the profits that these different entities make to the parent company, through the parent company, to the shareholders, who are the ultimate beneficiaries. And of course, they are protected through limited liability devices from potential liabilities of the company. I embed this discussion in the history of the Dutch and English East Indian companies to show where the corporation comes from. And so I always try to combine a little bit of legal history with more contemporary applications. For that, I'm basically walking the readers through the story of a particular securitization structure that was done by New Century, one of the mortgage originators in this country, that failed already in the spring of 2007, 1.5 years before Lehman Brothers went down. But you can basically use that story to show how property law, that's the ownership in houses, mortgage law, right? Sort of the security interest that a bank gets when it gives a loan to buy a home. Trust law, because once you buy all these mortgage loans from an originator, they will all be thrown into a trust, and the trust then issues interest to investors. How you use this basically to create the kind of structured finance, parallel banking, shadow banking structures, whatever you want to call them, to create enormous amounts of claims, typically fixed income claims, which is what the private sectors want, through these legal devices. And these interests are sold globally. Right? They're traded globally, not in a liquid market, but they're passed on globally, because for some reasons people trust that they will be enforced. There were cases in the courts ex post facto that showed that many legal requirements were actually short-sighted in the structure of some of these mortgages, and so some people shouldn't have been evicted, and they shouldn't have been forced to give up their houses because the documentation of who held what right when was just very, very sloppy. But nonetheless, it shows you that we can scale a market in a simple promise to future pay. That's what debt is all about. But we can scale a global market in not only the credit instruments themselves, but in the derivatives. And the derivatives, of course, take the form not only of the immediate derivatives, but we have squared and cubed derivatives as well. And then last but not least, I use the case of know-how. And here I basically use the example of patents being granted in the United States to essentially the DNA, what I call nature's own code, right? So nature has its own code. That is the genetic code, and there's an old rule in intellectual property rights that what is of nature should be accessible to everyone and cannot be patented. But the U.S. Supreme Court has developed principles: if there's any kind of human manipulation of what is nature's, that manipulation as such can be patented. And so they had granted a company a patent over the BRCA breast cancer gene, which had used that to enormous commercial gain because they monopolized then the market for testing women and used that monopolization of the test to build the biggest database ever in breast cancer genes. The patent was in part struck down by the Supreme Court in 2013, but about 20 years after it had been granted. In the meantime, of course, the company made a lot of money on that patent, and it had built this huge database and could use this database, its monopoly over the database, which was then also protected by trade secrecy law, to continue to make enormous amounts of money even after the patent had been struck down. Some folks in the literature have called this data generating patents. So that's sort of the technological ability to use data today is, of course, also a source of wealth. Something I don't discuss in this book, but it's part of my current ongoing research, and using patents to create a database and then use trade secrecy law in combination with technological devices is another way to monopolize assets and protect them against others. Next slide, please. So instead of, I gave you basically a snapshot only of the different stories I tell in the book. What I think is more important, especially since we're talking here in a transnational setting, you're in South Africa, I'm in the United States, and of course there's so many global transactions, which currently have come to a halt to some extent in our COVID crisis, but we'll come back. The point I wanted to make here is, first of all, to just set up a puzzle so that you can see I'm trying to challenge my own argument, but also I'm trying to solve the puzzle that I will give you. So here's the puzzle. The modules of the Code of Capital that I explained to you, the property rights, the collateral law, the trust, corporate law, contract law, bankruptcy law, are all modules of domestic law. We don't have these legal elements embodied in supranational global law. There's some, of course, we have the United Nations Convention on the International Sale of Goods, which is a partial contract law for the sale of goods, but it's just no match for national legal order. So the point here is that the law that we use to code capital is predominantly domestic law. There's no global state, there's no global law, but I think we all agree that we have a global capitalist system. So that should actually defy my thesis, right? That if you have capital is coded in law and it's in domestic law, how can it possibly be global? So let me go to the next slide. The way I resolve this puzzle is basically to argue that in theory, a single domestic legal system could sustain global capitalism as long as all other countries recognize and enforce the legal privileges that have been created with these legal devices. In fact, we have not one but two legal systems that dominate global capital, and that's the English common law and the law of the state of New York for financial assets. For corporations, you may also want to throw Delaware state law in the mix, so you could just say US law and English law are really the dominant legal systems for assets that are traded globally. It's certainly true for financial assets. It's not easy to come by with exact numbers, but just as a rough estimate, we know that to the extent that sovereign debt by emerging markets is issued under foreign law and not their own domestic law, so that they can get cheaper access to these markets, these assets are typically issued in English law or New York law. Sometimes it's a different legal system, but there are not many others that are powerful contenders. We know that the derivatives markets is governed for the most part by English or New York law. We know this because the model, the master agreement of the International Swaps and Derivatives Association, for example, advises its members to use English law and English courts, New York law and New York judges as a matter of choice of law and choice of court provisions in these master agreements. It's not the case that everybody has done this. A couple of cases about these derivatives ended up in a Korean and South Korean court and some others, but for the most part, people have abided by that. And so I think for this huge market that went into the trillions of dollars before the crisis and has picked up to some extent after the crisis, it's again English and American law. And these devices are recognized not only by English courts and American courts, but also typically by foreign courts, some exceptions notwithstanding. Next slide, please. Okay, so everybody knows that we have a couple of global financial centers. So far still, I think they're mostly London and New York. Currently, at least before the COVID crisis, but I think this hasn't changed really much. But New York has a little bit the edge because of the UK being bogged down a bit by Brexit and uncertainty about its role in the future. Neither the US nor the UK have done particularly well in the COVID crisis. So we will see what happens afterwards. But my suspicion is that there's a powerful network effect here. But the point is that these two cities, London and New York, are not only the centers of global finance, they're also the centers of global law. Can I have the next slide, please? Is there one in between by any chance? Or maybe the next one. I just wanted to go on. Yes, that's what I wanted to show you. Maybe we can go back afterwards. Yeah. So when you look at the top global law firms, and that's very simply defined as a firm that has operations in more than one jurisdiction. And I gave you only the top 20 here, but it's the same when you go down to the top 100. All of them are Anglo-Saxon firms, with no exception. They have sometimes merged, of course, with major French or German or other jurisdictions firms, but they're all Anglo-Saxon firms. Many American firms also have set foot in England, in London, and have major operations in London, such as Allen & Overy. It's one of the major law firms that has advised on the derivatives markets, and they were behind sort of the master agreement of ISDA that had advised ISDA for long periods of time. These firms, is basically what you can say is that the globalization that we are seeing, especially in finance, but it's also true to some extent in the trade of goods and in services, is a globalization of Anglo-Saxon legal practices, with lawyers from their firm setting up shop in other jurisdictions. And if they don't advise on the local law, which they may not necessarily be allowed to do, they nonetheless can advise on the nature of, on the way of how you code assets, right? And so you see very often in different jurisdictions that local lawyers adapt the techniques and transpose them into domestic law to make this possible. But you also see in major jurisdictions that include countries such as Germany or France that certain aspects of the law, certain legal domains such as capital market law or merger and acquisitions, over 50% of market share lies in the hands of firms that now have merged with a local firm but are clearly governed by Anglo-Saxon legal practices. So that's really, I think, a powerful force behind globalization. So if you can go back to the slide, maybe in between, or that came afterwards. Yes, so I have a whole full chapter devoted to that. Of course, at some point you have to ask the question, if I say, capital is coded in law, so the question is then who's done it? And I call the private attorneys the masters of the code. Now, the private attorneys don't really like that. Some like the term masters, but they don't like the responsibility that comes with it. And I do understand that they are in a kind of a complicated predicament, in the sense that they're, of course, dependent on their clients for the fees that they earn. But my major point is that the clients, some of the clients also, I talk to some traders they basically say, well, the lawyers just do what I tell them. They don't really add anything. And so my question then is, could you do what you're doing without the lawyers? And universally, the answer is no, of course not. You have to code these things in law. The point is that you have to make sure that the claims that you are creating, and these are future claims, that they are sufficiently credible that others will buy it and will buy it on a global scale. And for that, you have to make sure that it's in principle enforceable. Right? It's in principle enforceable. There's never a guarantee, and lawyers will cover their back by writing this into the contract itself, but you have to make sure that it's enforceable, and that means two things. One is you want to use the legal devices I discussed to create assets that give the counterparty sort of a sense that they are secure, that they have a collateral interest, they have a property right. So they feel secure because they have these enforceable claims. They sometimes forget that they still need some assets that stand behind that to have something to enforce against, right? And in times of crisis, that foundation breaks down. But they have the sense that it's enforceable. The second thing is that in principle, these assets have to be compliant with regulation. So you have to code these assets in such a way that they are legal, because otherwise they might be void and cannot be enforced, and the whole thing falls down like a house of cards. So one of actually a practitioner that I've been teaching with over some years, and she also brings her clients and her partners to my class. She basically explains this always to my students by saying, you have to think as a lawyer when you do these kinds of transactional lawyering, you have to think about the regulatory regime, and maybe multiple regulatory regimes if you work in an international setting, as the scaffolding, and you have to fit your devices through the gaps within the scaffolding. If you hit a pole, it's dead on arrival, right? So the idea is that you arbitrage basically around the regulations to make sure that you have assets that can be devised in this, can be enforced in the end. And how do lawyers learn how to do this? I teach at one of the major feeding schools for Wall Street, Columbia Law School. So we teach them corporate law and securities and collateral law. We teach them all the techniques. Most of it, however, they learn on the ground. There's a lot we just don't fathom as just legal theorists unless we do talk to the practitioners. We also of course, train not only American lawyers, we train thousands and thousands of LLM students, and they bring back these ideas and practices to their home jurisdictions. Okay, can we just go on? Yeah, so then there are, of course, multiple normative issues that this book raises. There is also, as I said, a couple of theory issues that I think that have to be addressed, such as what is the theory of the state really beyond what I said earlier. But I just want to just come down on a couple of, on one of the most important issues, and that's, of course, the tension between a private legal order that gives private agents, clients and their lawyers, and given the price of lawyers, of course, not every individual can afford the kind of lawyering that gives you the wealth that you want, but that gives these lawyers and their clients a lot of flexibility in devising their own interests. And that's part, of course, of a private legal order. It's not dictated by the state. It is malleable. It's flexible. The idea is also that people invent not only assets and things and new machines, but they also invent new legal strategies to do things. And I don't want to vilify that in principle, but I also want to say that the processes that go into the coding of capital are oblivious to democracy or constitutional orders. As long as it fits within their coding strategy, it's just fine. And so there's a tension between we the people, as the American Constitution says, and the idea, and many other constitutions do, the ideas of basically of democratic self-governance and a private legal order that gives a lot of flexibility to the private coders, because and I think in particular during our in our age of globalization, this has become to the fore even more so than earlier, because the typical devices that we use to rein in what happened in the private coding, such as regulation or taxation, can be relatively easily evaded with exactly the same kind of mechanisms that I described. And so people opt out legal systems and opt into different legal systems. As I said, English law and New York law is really critical for globalization. It's not clear that the voters in New York know that, and that this plays a role in how they vote for the parliament that might make these rules, but a lot of the rulemaking, of course, also happens in courts, and so the democratic control over them is even more attenuated. And so I think we have to think about how sustainable our democratic constitutional legal orders are if we continue to give the kind of flexibility, including the ability to outsource, opt out, opt in, different legal systems, basically commodify law, right? This is what's happening. It's at the bottom of that is the commodification of law, and I would still claim that law is a social good. It works only if it's enforceable. It works only if the coercive powers of the state are behind it, and how we institutionalize this coercive powers is really what defines who we are, not only as a nation but also as an economy, and defines the level of inequality that we might have. One more slide. I'm almost done. Yeah, so this is a democratic challenge. We can skip that. I basically said this already. So what I discuss in the book might sound a bit timid to you, and I probably would go beyond what I wrote and I last wrote in the book. I mean, and it came out exactly a year ago. So last time I had a chance to make any changes to it was in 2018, late 2018. And of course, the COVID crisis and what happened since shape your minds, as do many conversations I've had with people about the book. But I just want to highlight what I was trying to do in the final chapter is to say, what can we do to roll this back and gain against more traction over what is happening in the coding of wealth. So one could have much more radical solutions. You could say we want to go, nationalize, or we want to cabin certain things completely. And my thought was, given the sophistication of coding that I've observed, and it didn't just start in the 20th century, you can track coding devices by English lawyers in the 17th century, where I just thought, okay, if they did this then, right, no wonder they could do derivatives today. So you could, of course, argue just take it away completely. That takes away a lot. And so I think I'm still sufficiently committed to the idea of competitive markets, but truly competitive markets with fewer legal steroids for those who can afford the lawyers. So my impetus in this chapter was mostly to say, how can we roll this back, and can we take a page out of the script that the coders have written for us for centuries to learn how to do this? Where are the vulnerable points? What do we have to take away to basically take away the punch ball, make sure that people have to internalize the risk that they're taking, that they can't just rely on these legal steroids to generate wealth and hide it from the rest of society. So a couple of just very simple points, some just bright line rules, right? So there's so much power that people have when you have these private legal institutions at your availability, then we don't need additional exemptions, carve-outs, or safe harbors, right? This is the term that is nowadays used. It was used for bankruptcy. It's used in many international negotiations. So you want to safe harbors, which basically means you exempt some from the rules that everybody else have to abide by. There should just be a default rule against that, just no. And if you want to make a case, the burden of proof has to be on the other side. It's just not to say we will increase the pie. It's not enough to say we'll increase the pie and everybody will benefit, like all boats rise together. We know that they don't, right? We have enough data now, thanks to Piketty and his group, that that's just not the case. I think we do have to limit the choice of law and choice of forum provisions to some extent, not absolutely. Some competition between jurisdictions is always a good thing, but some are going too far. And then the question is how to remedy this, right? So I think one way to deal with tax evasion is simply to deny corporate legal status, entity status to the entities that you use, right? You can, of course, blacklist some sovereign states that are tax havens, but you could also simply deny corporate entity status to these entities, something that is just not touched upon because, you know, as was said at the beginning, Firas made the point, most people who think about inequality and redistribution think about redistribution through public law means, and the private law is sacrosanct. Many private law professors, scholars I know have said the same to me when I presented the book. So why don't you do this through regulation? And I'm basically saying, well, that's basically too late. When regulation always seems like we're taking away something that is owed to that person. And the point I want to make is actually you owe this to us, to those who are sponsoring the legal order, because it's also ultimately a social good. And if you basically make use of these legal devices, we also have the ability, or should have the ability, to constrain this. Similar, like private arbitration without any court oversight, I think is going too far, certainly in this country, where even in employment contracts, they can use mandatory arbitration clauses and deny class action. So this is basically denying individuals access to the court system. That goes too far. Preventing externalities that result from excessive coding. So limited liability is an issue not only for hiding taxes, I think it's a huge issue for environmental harm. So thinking about how to make sure that investors price harm correctly, I think we should toy at least with the possibility of giving pro rata liability to investors who invest in these firms. And of course, holding the companies liable in the first place. And then other mechanisms that we've used in the past that are being pushed back and scaled back, I think should be brought back to the forefront, such as treble damages, shifting the burden of proof, class action suits. There are a lot of mechanisms that one can use to tame the beast a little bit, and we can use from, learn from past practices, also learn from how they have been eroded, why they have been scaled back, etc. And then last but not least, this is a controversial point, but I just want to throw this out. One of the mantras that you will hear from the financial sector in particular is that they always claim that they need legal certainty. So they will accept some regulation, but they want to have absolute legal certainty. And I'm basically saying, well, let's just take this back, because legal certainty means that you can completely rely on your legal coding strategies and get out of it what you want. And it's a huge incentive then to arbitrage around rules and regulation. So if we keep you on your toes a little bit, whether this is really enforceable, you might actually think twice before you use a particular strategy. And one way to do this, of course, is to rely a little bit more on standards rather than specific rules that are easier to arbitrage around. But there could be more of that. And there certainly should be a debate about the extent to which legal certainty is something that is owed to a sector that is using it primarily to produce private wealth, not necessarily national or social wealth. Let me stop here and take your questions.
That was great. Very provocative, I think, for South African lawyers who tend to think about the law also simply as progressive lawyers, that is, as an ameliorative facility. Whereas here we have an analysis, suggestion that law can be constitutive of unjust social arrangements in some way. So going forward, this is how we will proceed. I'm going to ask Professor Albertine, who's holds the research chair in Inequality Law and Social Justice Studies, and who is part of this joint project with the Southern Center for Inequality Studies, to make some observations as a discussant. We will then open up the discussion for questions and comments. Can I ask colleagues who want to participate in that way to do one of two things? Either to use the chat function or to use, I'm not sure what to call this, the hand function, not the Nazi salute, the hand function. And I will then, you can then when you're putting your question, when I invite you to put your question, you can unmute, so Katharina can hear your question, and momentarily, if you like, also unmute your video, but then please go back to mute, because we don't want to overload the system. So I will allow, with some flexibility, as many of you who want to participate, there are 30 of us. Then at the end of this process, Professor at the center, also partnering with the Mandela Institute project, to make comments to respond actually to a sort of a lawyer's analysis of inequality as a sociologist. And let's see where we can go from there. Kathy, floor is yours.
Okay, now am I fine? Thank you. Thank you, Feroz. And Katharina, thank you so much for agreeing to talk to us. As very much a private lawyer, I was completely inspired by your book, feeling in a way that I'd learned much more about inequality than I have in a couple of years of working in human rights. So what I want to do, I think, is just really pull out 3 points that you really have already made, and try and just frame them as questions for us in South Africa. And I think the first point is one that's already been made by Feroz, and that is, obviously, this is a book about private law. It's a really compelling analysis as to how private law entrenches and reproduces inequality by coding assets as capital, but then as also defending and protecting them to generate long-term wealth for the few. And of course, in South Africa, with the exception of a few private lawyers, most of our debate has been in the area of human rights, of constitutional law, and in public law. And I think your book very clearly shifts the gaze, not necessarily away from public law, but towards private law as well, towards those areas of private law that you spoke about. And as an aside, I also think it shifts our gaze towards our methods of legal education, and how we teach private law versus how we teach public law. You know, public law is the progressive law, private law is often the conservative law. And there's big contestation in South Africa about the extent to which constitutional values, for example, would be relevant in private law. For me, it also talks to us about the kind of lawyers we want to produce as legal educators. Do we want to produce lawyers who are going to go on to code capital? Or do we want to produce lawyers who are going to do the radical or the incremental changes to recoding capital and to building more egalitarian societies? So I think that's a really interesting area of debate for private lawyers, but also between public and private lawyers around understanding private law, but also understanding in South Africa the intersection between the public and the private. The second point for me that I found fascinating was what you were saying about the nature of law, and more particularly how we need to understand, and again, I do acknowledge that I speak as a public lawyer here, but my sense is that I need to understand in far more breadth and detail the nature and operation of private law in South Africa. I wonder sometimes whether we don't focus way too much on legislation and case law. Yet what your book is saying to us is that because of law's indeterminacy, its open-endedness, and its malleability, a lot of what goes on in terms of coding of capital and the way in which private law works is behind closed doors by private lawyers and not within sight of parliaments and courts. And of course, I think you're saying more than that. I think you're saying even beyond South African closed doors and offices, in the offices of New York and London. But it seems to me that even as South African private lawyers, that we really need to engage and understand more the kinds of practices that you're talking about that are outside of public documents and public forums. And I think you said earlier on that are activities that are often oblivious to democracy and the constitutional order. So trying to, in a way, understand that gap and find ways of closing it, I think are essential questions for South Africa. And I think the third point, and maybe the final point that I want to raise, because I think that the audience really needs to engage you on the detail of your book. And this is a personal interest, is how do we use law to shift from inequality to equality? And what kind of question is that for private laws? Particularly, how do we take important questions of wealth distribution from private choices into the public domain? And again, it's a point you make a lot in the last chapter of your book around moving from the kind of closed off sphere of private autonomy to much more collective and egalitarian interests, how the public voice, how the sovereign people have some kind of say in the regulation of wealth. And you engaged to some extent with some of the ideas that you do in chapter 9, and I think they also are a very good start for the kinds of conversations that we could have in South Africa around how we begin to recode, let me say recode capital, how we begin to deal with unequal wealth distribution. And I make these points because they're not only points about your book, Katharina, which is fabulous, but they're also points that I think we would like to take up in our seminar series as we go forward here in South Africa. That these are points that we really should engage. And I want to speak directly to my colleagues in universities and in the profession is to really welcome you to participate in that seminar series, and also to volunteer to come and talk to us as well, so that we can get these kinds of conversations going and think about how we bring about change here in South Africa. Thank you, Katharina, for a very inspiring presentation.
Thank you. Great comments. I'll wait for more and then I will respond a little bit. Yeah, thank you.
So thank you for that, Kathy. Colleagues, we're looking forward to your comments and questions. So I see Sanele. Please go ahead.
Yeah, let me unmute and then maybe put on my camera and hope that I am dressed for the show. Right. Professor Pistor, yes, thank you so much for a great presentation, and I think more so a great contribution to legal knowledge that has provoked a lot of us into thinking a lot deeper about how inequality is generated by the law. And I must say, I think in the first instance, I want to say thank you for the way that you use legal history. It's illuminating for us, and using legal history to reflect on contemporary contemporary manifestations of how the law generates inequality. Now, my question's a little bit, is one that's seeking some clarification, I guess. And I come from the South African perspective, where the land debate has focused a to a great extent on ownership, or the idea on the legal institution of ownership. And so what I want to ask is, in your book, in your schema, and in your presentation, you don't speak very much about ownership. And I want to ask where it fits in. Is ownership or private ownership in particular assumed? Is it something that's key, or is it something that's a bit of a ruse? Should we be focusing more on questions of control of assets or control of capital rather than ownership? And just where does ownership fit into the whole schema?
Okay.
Yeah, thank you.
Shall I answer directly? Is this happy to do so, but also happy to take more. Just waiting for guidance.
Okay, so these are very substantive questions already. It's really up to you. I can see 4 of my colleagues, or 3 more, Francisca, Dennis, and Chamaka. So, my thought is, I think let's perhaps have some responses, because I'm suspecting that the next round will be as interesting.
Yeah, well, thank you very much, Sanila, for this important question. So ownership, I basically talk mostly about property rights and the allocation of property rights. And then the question is, what's the relationship between the two? I think, it depends. It's so I think my understanding of the South African debate about land, of course, there was a huge debate, continues to be again a debate about restitution, whether just ownership of land gives you a level of freedom and autonomy that is owed to people who have been deprived of their land during the apartheid regime and earlier during colonialism, and should be restituted. And of course, we know that many have received cash instead. There's also the issue that once you do give access to land and you allocate title to land, that you have to think about what is what can you actually do with this. And then I think there is this issue of durability. So one thought, and I'm really not an expert on South Africa, but I've followed the debate a little bit. I teach also law and development, so I'm looking a lot about what happens in developing countries outside the West. And one of the issues that I learned, at least through my book, is that assets are key for building wealth over time, but you also have to have the right legal protection. So cash is not the same as having an asset. Neither is just sort of a regular social security payment. Maybe that's an alternative, but then should be an alternative for everyone, like a uniform basic income, sort of. But if you want to, give people autonomy and the ability to build wealth, then sort of having an asset such as land, could also be a different type of asset, is important. In cities, it's shelter and housing, but nonetheless, you can also think about financial assets that you can build over time. But the point then would be to, if it's about wealth creation, you have to think about durability. As I mentioned earlier, in the titling programs, what the World Bank is rolling out in so many countries, they completely forget about how you protect poor people against the onslaught of economic uncertainty in times of crisis. So yes, we have a problem with moral hazard, but the most important reason why people lose their shirt is not moral hazard, but they lose their shirt because of economic crises and or losing their job or things like that beyond their full control, and you have to build insurance devices around that. So in a broader conception of ownership, there's a long answer. In a broader conception of ownership, you want to give people sort of the means to control and organize their own lives, and having some control over some objects and assets is a critical part of that. I should just mention in passing, there's a great book coming out by Hanoch Dagan, who is an Israeli property rights scholar, who is basically writing a book, or has written a book, it's coming out in Cambridge University Press, about how property rights actually should be constituted, and to the extent to which in some ways, in some aspects of property rights, we do this already as basically a means for self-authorship, right? But a means of self-authorship that respects others and that is in constant dialogue with social groups, with society at large. And I could imagine a conception of ownership that also is more true to that. And, you know, countries have tried that. You know, the German constitution does it a little bit, the South African constitution does it a little bit, but bringing that into the private law, making it responsible to these ideas is important as well.
Great. Okay, so where I know the questioner, I'll just introduce them because, you know, so that because it makes it a little bit more familiar. So I'm going to introduce the next three who want to ask questions, and they will ask their questions without intervention from me, and then Katharina can respond. So Franziska Sacker, professor, is our trade specialist. Next, Justice Dennis Davis. I won't say anything more, Dennis. And then Charmika, who's a colleague in the law school and who's done some interesting work on the structuring of corporations in a colonial context. So Franziska, then Dennis, then Charmika.
Okay, thank you, Feroz. Let me try to switch that on. Okay, my question goes into a little bit of a different direction. So you mentioned the control of the legal firms that basically mainly sit in the US and the UK. And the same would apply to, and you mentioned that trade in goods and trade in services generally. I wonder why you have not included in the book the competition law aspect of that, because specifically the international cartels, be it exports or import cartels, in my analysis, contribute a lot to inequality generally between nations. But when you look at the individual, I maybe would include small participants, small economic operators, specifically in developing countries. So that would be, in my opinion, a large contributor to inequality. So I was just interested why in this you called it coding of wealth, which I thought is in the is exactly in those domestic and regional competition laws maybe included. That would be my question. Thank you.
Yeah, no, thanks for this question. It's also a really good one. And, you know, I don't want to just cop out of the question saying, well, you have to draw the line somewhere. I really wanted to go into the private law and the creation of wealth. And I think part of that, and I could have said more about that, is about creating monopolies, right? It's controlling the market. It's protecting yourself against too many others, whether these are competitors or creditors. And I might have said too much about the creditors and not enough about competitors because I just do more finance. Maybe that's why the choice. But I fully agree with you that what is happening, we're using is exactly the elements that I'm talking about of the code, the modules of the code, corporate law, right? To create sort of entities, to build them up. You use contractual devices and other things to make sure that you can control markets in a certain way, and that also contributes to wealth. So I think I could have told that story too. Competition law, of course, on the other side is how to constrain it. It's like the supplement, like taxation, where you say this is where we can use progressive taxation to redistribute some of the wealth. I really want to look at the creation of it, and especially also in our world of big data. I take that point. I could have said more about how these devices are not used on a case-by-case basis with one entity, but you're really creating empires, right? Economic empires with these devices that are protected, that allow to give them market share and market control that is very powerful, and where we have very little pushback actually in competition all these days. So yes.
Thank you.
You're welcome.
Charmika, you next?
Hello?
Yeah, we can hear you.
Hi, thank you. Sorry, I'm just going to use the audio. Just also thank you so much to Professor Pistor. I think one of the most exciting critical interventions that the book makes also is the challenge to the assumptions of the inevitability of both the instruments, but also their consequences. And I think that the radical implications of this across disciplines is especially kind of, I think, refreshing. But also, kind of in the direction of my question, I want to ask then that the challenge of the inevitability also potentially puts or re-emphasizes the assumptions of neutrality. So in my own work, I do kind of an interrogation of the idea of legal or juristic personality, and essentially make the argument that the company has been an instrument and continues in some ways to be an instrument of coloniality. And the question then is, especially to the significance of private law, are the implications also not simply that there's been an oversight, but perhaps an elision of the normative values, not only informing the code, but the actual coders? And in some ways, does this kind of change the nature of our kind of the discussions and the acceptance of a silo treatment of private law as distinct from public law? So just kind of putting that question out there as well, in the sense of, is this also a call to actually kind of trouble some of the assumptions of the empiricism or the absence of kind of kind of normative and ideological influences in some spaces as opposed to others? I think I'll leave the question.
Yeah, thank you for that question. Yes, I think it is. I think that it comes out of this. I could have been more explicit about this, but of course that's something that is at least between the lines in the book. It's the assumption of neutrality. I basically show how law can be instrumentalized to create wealth, and it's also the legal institutions. You know, if I go back to Bernard Brudden's quote at the beginning, property rights were first created during the age of feudalism, right? And we transpose the same mechanisms just to different assets. That's what the legal coders do. They've learned how to specialize in the coding, not in a particular asset, right? So until the end of the 19th century in England, they were basically coding the land of the wealthy. They know exactly what they were doing. And they started just coding whoever, you know, any client's interest that would come their way and would be willing to pay their fees. And the lawyers, they resent this idea of being responsible. They resent the agency I give them, right? So they don't want to, and I find this interesting because they basically you know, they're very smart people and they're willing to basically argue that they're in the packaging industry and just packaging the stuff that their clients want, and they have nothing to do with it. As I said before, I think they're instrumental fundamentally in there, and they have to think about this, and what they're doing has normative implications. That's what I teach my students. I know that there are instructors later on where they can't realize this idea, but at least I want to imbue them with these ideas. So the law itself, but also the agents who are using the law, I think, have to understand that what they're doing is just not neutral. And in a way, I also want to shift the debate more generally about law and private law in a different direction. So I recently published a paper which I call The Value of Law, and say that at the beginning I'm talking here not about the normative value of law, but the monetary value of law. So how law can be used to maximize monetary return. And this goes back to the point I made at the end about legal certainty, which sounds such a great and you know, undisputable sort of shared idea that law should be certain. But if legal certainty is granted in certain areas where we know it's used for private wealth creation at the expense of others and the protection of wealth against others, then I think there has to be some line drawing here, and so the commodification of law in that sense has to be curtailed. And again, this is what, you know, the first point I wanted to make is just to clarify for people what you're doing is something you're using a social asset for private gain, and that's okay to a point, right? That's why we afforded this. That's why we have a private law system. That's why what it's for is to organize markets and to also create wealth. But the extent to which it's being used to create excessive wealth for very few is what I'm getting at. let me just maybe say in this context also a word about Kathy at the beginning. Where do we go from here? Can we recode? I mean, that's something, of course, that's also really very much on my mind, especially now during the crisis, but has been since I wrote the book. It's always relatively easy to write a critique. Saying how you would change the world is much harder. So I've been thinking with students, for example, about different firms, different types of firms, worker-controlled firms, and looked at cooperative statutes in this country, which are totally outdated in comparison to what we have in corporate law. So, I've come down basically saying you can write a really nice contract for a worker-controlled firm using the limited liability statute of Delaware. You can do so much more with this than being hamstrung by laws that were never changed because there were never the lawyers there. They pushed for constant change of the law in response to social change. They're basically outdated, rigid kind of legal rules. So I think there's a lot of space in reorganizing and using both legal tools but also technology to think about how firms could be organized in ways that is different. That's just not only the shareholder value maximization model, but there are other values that we can realize.
Dennis, Justice Dennis Davis.
Thank you for fine. Katharina, well, very nice seeing you again.
Good to see you.
And I wonder if there's so many things that one could raise. Let me just raise a couple questions from your presentation. It's interesting, as I indicated, I think the time when we spoke, it seems to me that this book comes in the great tradition of Hale and the critical realists who essentially have totally forgotten or not used or not even thought of in South Africa, notwithstanding our constitution. And so if I then take somebody from a similar tradition like Renner, my question is, it's curious that Renner spoke about the idea that the concept of law remains the same, but the content changes. And therefore, the question which really interests me is, why is it that in, say, many countries, including our own, which I think is the point Kathy Albertine was making, is that there's been no impetus to change the content to curb the levels of inequality. Now, what a role then does legal culture play in this? Not just the training of students, but the way lawyers think. The compartmentalization between the private and the public is one aspect, but the whole dominant discourse, the framing of law that lawyers traditionally use, doesn't seem to me to allow them to expand the lens to do, in a sense, the work that you're doing, or alternatively to think through how you could recode capital. I'm interested, perhaps as a first stab, as the question of the role of legal culture in the reproduction of this kind of coding. The second question is the fascinating one that you raise with regard to the fact that we don't have a global legal system, and yet thanks to certain dominant legal systems, ultimately this code of capital is reproduced. So the issue then arises, what happens to countries, and I suppose this goes to a theory of state, which you've spoken about, what happens to countries that seek to do exactly what you were suggesting in the last bit, in the last chapter or the last slide, that is actually try to reconfigure things. So if you take South Africa as an example, a middle-ranking developing country susceptible to all sorts of exigencies of international capital. Now, what happens if countries like this do ultimately say, well, we read the Code of Capital and we think we do want to recode capital in a particular way because we want to, given the fact that we're the most unequal society in the world in statistics, we want to do something about that. So the question, I suppose, that arises is, even though it's not we don't have a global system, even though you're quite right to suggest that nation states are the transmission belt for the reproduction of what you're talking about, what is this, how does this work absent, let us say, a broader consensus in the developed world to allow the kind of arguments that you're suggesting to take place? It's a complicated question, but it seems to me very important in the relation to what we're talking about. And I'll shut up. Sorry.
Yeah, no, thank you. These are, I think, two big questions. So let me just at least try to respond to them. The first one is about legal culture. I mean, I think one of the things that is just inherent to the law is that we always connect the past to the present and the future, right? So the legitimacy of interpreting something is because that is the law. This is why we've always done it this way. Or we want to also create predictability and reliability, as Max Weber and others have taught us, but they also, of course, he picked this up from the law. He made, however, also this very interesting observation that as sort of we are creating predictability and also some kind of uniformity of the law, the entrepreneurs always want to have their own particular legal system, right? Because they want to have certain types of legal privileges. So this is the combination, I think, on the one hand, that there's something inherent in the law of reproducing the past, which is what gives us stability. We can rely on a precedent in the common law system. We can also rely on the stability of the legal regime in the past, and that somehow binds us to the past, makes it very difficult to change, which is also why we see so much reproduction of old stuff, even after a regime shift, right? I'm not sure whether you have read sort of Piketty's new book, Capital and Ideology, where he says it's all about ideas. And yet I think he also documents in this book that, how fast after the French Revolution, old inequality was at the same level, how fast that happened. And I think it happened because it's a combination, of course, pure power, but also using the legal institutions that exist and can't be all redefined from one day to the next to reinforce the structures that we have. And having access to the law and the shaping of the law, therefore, becomes absolutely critical. And of course, as we know, not everybody has equal access to the law. And then the lawyers, that's sort of the consciousness of the lawyers, they're sort of trained to think like lawyers. They're trained, we learn certain types of skills, but we also are acculturated in a certain way, and different legal systems do it a different way. But when our legal methods classes that I taught to our 1Ls at the beginning of the term, when they come in, is basically how to think as a lawyer, which is just essentially conservative and stands in the way of more radical change, almost necessarily so, because that is, I think, part of the law and its legal change. There can be moments of change. I mean, you have that, of course, in South Africa, and it was important. I would also say in Germany was important. In Germany, we even have constitutional court decisions that then came out and said the old private law has to be interpreted in light of the new constitution. You can't just ignore that. So you to try to infuse it, something that is much less done in the United States, interestingly enough. And the originalists basically go back to the old feudalist common law to retain their interest. So I think there's a combination of power and also maybe an abuse of the conservative nature of the law. But I think law as such is conservative to some certain extent, because otherwise it can't provide the stability and predictability and also the legitimacy that people are craving in the legal system. The second question is what happens when you opt out and you do it differently. I think one thing that I still have to investigate closer. I have a good friend, Mariana Pargentla, in Sao Paulo, in Brazil. She says, actually, in the Brazilian legal systems, many things that you're talking about actually are very different. So limited liability is not as guaranteed and can be fudged. And there are a lot of outcomes that you might actually not want. So I think this would be an interesting case study, is what actually happens when you do this and what might replace it. But I would also say, and I think Brazil would probably be a case where if you can opt out of the system and still use then a different legal system to do the same thing in your own country, then it's just not really a fix, right? So as long as there's sort of the ability for those who are best resourced in the law, and I've visited law firms in Brazil staffed with former LLM students from Columbia who do a lot of coding in Brazil, and I think they probably know how to get around this. So the dilemma that we face, I think, is that on the one hand, once you pin it down as private law, you could also actually change it locally. You don't have a global treaty to change it. But at the same time, as long as the flexibility to opt out and opt in is retained, which you may want to a certain extent, local fixes will not change the system and probably will be outmaneuvered, right, by simply changing different legal systems. I mean, just the capital will flow to another intermediary, and you will get access only if you have dollar-denominated. God knows what. I mean, it's just, we know these structures, right? How they work and how they will be replicated, and it's difficult to climb down completely on them. Although it's also, again, not entirely impossible. But these are very good questions. Also, lots of food for thought. So thank you.
Gabriella.
Good afternoon. That's it was a really interesting presentation. I have a couple of questions as a European scholar, legal scholar. First of all, if you did not mention the European Union legal system as a leading legal system, but the European Union has been working a lot on its financial legal framework. There are many directives and in this area, and some technical regulatory standards compelling for the member states and so on. So what does the European Union lack to recode, to play a leading role in recoding the capital, the capital framework? This is the first question. I don't know if I was clear. And secondly, do you think that the blockchain technology can help us recoding the system? Thank you. Thank you.
Okay. Thank you. Well, on the EU, I mean, the simple answer is that the EU lacks private law in a way. I mean, it does, consumer protection stuff, but the contract law, the property law, the corporate law, it's all still in the hands of member states. The EU tried to harmonize corporate law, but what came out of it, sort of the regulation on the European, Societas Europea is a joke in terms of a corporate law. It's just a very partial corporate law, and most of the stuff you still have to get from member state law. So the private law institutions that I'm talking about is mostly member state law. Yes, the EU has regulation, and and has also created regulation, of course, for integration that has made it easier to code capital and to proliferate capital throughout the EU. Just think about the passport rule, which is one of the most contentious, has been the most contentious issues in the Brexit negotiations, because the EU basically created a regulatory regime whereby if you were regulated by one member state according to the common rules, then you could do your financial business in all member states. And of course, London wanted to protect that rule, even as Brexit forced the UK out of the European Union, and the EU correctly said, no, that's not what we're going to do. Now, so an interesting question that I think goes to the core, an interesting test case to your question is, what was going to happen after Brexit? Will London continue to be the major place where capital is coded, including capital that might be traded and used in the EU, or will that shift? And my guess is that because of the EU regulations that you mentioned, a lot of the retail financial services and the capital it creates will have to move to the continent and will have to be subject to continental regulations, not necessarily continental law. It could still be English law in many cases, as many corporations are incorporated in the UK, and that won't change, I think. But sort of but global wholesale banking can stay in the UK. So I think the EU makes a contribution. I should also add, I have a big debate with my colleague Anu Bradford, who just recently published the book The Brussels Effect, and she basically says the globe is coded by EU law, right? All the regulations, the big companies comply with EU law because the market is just too large, and thereby we're exporting European regulations to the rest of the world. And so we have, we have contrarian arguments, but I think we're talking also about two different levels. One is the regulatory public law level that's trying to constrain private law activities. The other things of the foundations of the private law activities and the legal foundations, which are largely, even within the EU, I think, in domestic law. I think the EU switched at some point from trying to harmonize the substance of private law to conflict of law rules. And that's exactly where you get the opt-in, opt-out, the whole case law about corporations from Centros onwards, that you can actually pick and choose your jurisdiction for your corporation within the EU, was sanctioned by the European Court of Justice. So in that sense, the EU has actually accelerated the coding of capital by allowing parties to choose the legal system under which they wish to be incorporated. On blockchain, so two things. I have one chapter in the book which I didn't mention, which talks about digital money mostly. It's against my bias maybe for finance, but it is asking the question whether the digital code might replace the legal code. And I basically walk through that question in my argument using money as an example. What I'm saying there is, yes, the technology allows us to make credible commitments and therefore makes us less reliant on court enforcement. So you can commit to do certain things and then you can automate it to a certain level and people can verify that you have only money that you can spend and otherwise you can't have access to that. There are some archaic things, especially in the Bitcoin world, that can be done differently. For example, that you can only spend money that you have. Well, our entire capital system is built on an economy where you spend money that you don't have, right? Because you use credit, for example, right? And of course, since Bitcoin is part of our world, many Bitcoins have been funded through loans, and so it's hooked at the hip here as well. But the principal argument is of course correct. You do a lot of smart contracts on blockchain that can be verified through technology, and you don't need the lawyers. What the technologists themselves, however, are realizing increasingly is that you cannot code everything ex ante. That's the point, right? Its contracts are incomplete. We know that, and the legal devices that we have, we allocate powers to certain agents who then make these decisions. That's why you have a management board for a corporation, or you write a trust deed, but then the trust deed has to be broken at some point because it no longer makes any sense, and there's a big case law about that. So it's similar, like you have to break the trust deed, you have to break the code, you have to get out of the digital code to adjust. I talk in my book about the DAO, the decentralized autonomous organization, how it crashed and how they then decided through a vote that they would go offline to fix the bug, or would split actually the code. So in many ways, I argue in the book, as the digital code raises similar questions that the legal code raises, and the technologists ignore that because they don't know anything about the law, and they're also reinventing many devices that we've had for centuries. Some things that I think they have a new token, and I look at it and think, well, this is a bill of exchange. Tell me what's new just because it's now on digits, right? So there is some innovation there. I think I wish they knew more about both economics, finance, and the law. And it's certainly not happening in a completely legal free space. It's also something that they constantly discover, that the SEC comes after them if they do an initial coin offering, because it is a security what they're doing. And so it's much more hybrid than saying either or. But there's potential here, but I think it has been overrated at the beginning. We're just learning how to use the technology in combination with legal devices.
Sanela, second bite.
Yes, Mirge. Just a very quick one, something I forgot to raise. So in your last slide, with respect to strategic incrementalism, ever given any thought to liability of the coders? Because I think that's the one thing that we don't see. We talk about touching on other aspects, limiting the types of transactions and so forth. But the one thing that also comes through very, very strongly in your book is coders who can code and then step back and kind of throw their hands up in the air, even if it was denying them fees in certain instances, not simply just denying them costs from the other side, but denying them fees. Ever thought about that?
Yeah, I mean, I do have a quote in the book from a book on English railway capitalism by I'm just blanking on the author right now with K. Anyway, so he has a quote from a railway gazette from the 1830s or so, where it basically says, well, the lawyers are always in there. They're also very often participants directly and invest in these firms, but they of course know how to cover their backs, right, and cover their tracks. One interesting thing about the entire global financial crisis of 2008 is not only that hardly any of the finance people were charged. We had some insider trading stuff, but we had no real major criminal case except for smaller folks. Typically the smaller ones we hang, and the other ones we let go. And no lawyer. What is interesting, and I discussed this also with a lawyer with whom I co-teach with my students, when you read the prospectuses that were used to disseminate derivatives and securitized products, right? So the securitized mortgages or derivatives, when you read them in the 1970s, when the first securitized mortgages were circulated, you read them again in 2006. The one section that has expanded the most is a section on risk warnings. So the lawyers have warned the investors about every risk along the way. They're smart enough to do that because that limits their own liability. So, I'm not sure I would want to go as far as saying, well, even if you warn them, if you know that's going to happen, then you shouldn't, then it really raises a fundamental question about how much agency you want to give those lawyers. But what is, also when I talk to the lawyers that come to my class, I always ask them, when did you know that this financial system would not be sustainable, the one that crashed in 2008? And I compare this, it's just anecdotal, but I compare this with what Volcker said or some leading economist said. The lawyers always knew this earlier. The lawyers knew when they were doing 40 transactions of this kind a month that this could not be sustainable. And of course you do it, but you write everything that could possibly happen to any investor who's caring to read, and nobody is, in the perspective to cover your back. That's what the lawyers do. You have a point. I think the way the lawyers go after doctors in this country are physicians. You could also say, well, why not have a particular task force that goes after the lawyers with their malpractice? But then the question is the malpractice vis-a-vis this client? Is it vis-a-vis the state? And this ultimately raises the fundamental question, which is also difficult to discuss in this country, much easier to discuss in Europe, is whom do lawyers serve? Just the clients or society at large? Are you an agent of the rule of law? You're just an agent of your client. In the US, without any doubt, you're an agent of your client. That's what you are. Lawyers here were like in the Wild West. They came with a bit, just quite a bit of legal knowledge. There was no bar, there was nothing. They were advising their clients. That's the tradition that is here. But if you want to say they're also agents of, the rule of law, and you can maintain that, which is hard to maintain under the onslaught of American legal practice, even in Europe today, then you could say you're violating some of these principles, and there might be at least a disciplinary proceeding against them.
Colleagues, any further questions before I call on Eddie? Well, I'm going to call on Eddie now. Eddie's
Rose, it's Kathy. Can I ask one quick question?
Yeah. Please go ahead, Kathy. I didn't see you. Sorry, go ahead.
Yeah. It's the question about the opportunities of the current crisis, and it's linked to the question as to whether the coding of capital really does change as we have different epochs, as social democracy sort of moves into neoliberalism, and maybe now we're moving into a more redistributive age, and maybe we're not. But do you think there are opportunities that are presented by this moment?
Yes, I think so. It's going to be hard to harness them, but I think they will be absolutely critical. So I wrote an op-ed in March in The Guardian and said we need debt relief, real debt forgiveness, especially in countries like the UK, the US, where small households, we have substituted social services with credit, basically access to credit. And when the future changes radically, as it has for many people, not for all. I'm fine. I get my salary. I teach online. So far we're fine. But so many people have, for them, the future has completely changed in comparison to the past when they made the commitments that bind them. And even then, I think it was irresponsible to force them to take on credits all the time to just make their ends meet. I would hope that that we go not only sort of not in the direction of thinking about really massive credit relief for those who really need it, not the big airlines, but the households who really need it, and that we also think about how to get off the hook of just being dependent on credit to that extent. And that sort of would then require to think about how to make sure that these people have a livelihood outside that. So whether it's sort of a state guaranteed employment or a minimum universal basic income or concepts like that, there has to be a combination of the two so that they don't fall prey to the next creditors again. So that's for me right now the most urgent thing. Beyond that, there are issues about what forms of organization are available to people who want to rebuild a business. Could it be a worker-controlled entity, and how can this be organized? They could use digital platform cooperatives as an entire movement. I'm working a little bit with them as well. So I think there is a potential, but I think there has to be decisive decision making also from the top. This can also go back, to digitals. I think the central banks should give households access to the central bank, and so that they can provide them with necessary means in times of crisis. So you can think about central bank digital currency and accounts with central banks. There are lots of things and I think that the key is a lot of people are talking a lot about these issues. The key would be to prioritize, and that of course has to be context specific. What are the most urgent things that just to help people right now in the crisis, and to think about how we can then use that also as a strategy to move forward. what is happening in the United States mostly is just we're patching up the system once again as we did after 2008. We're patching it up a little bit better, but $1,200 doesn't get you very far in this country, which is the check that households receive. So I think other countries, if they have the political will and ability to do so, should think further and should think how to restructure the system, use this as an opportunity to do so.
I don't see any other questions, so I'm going to call on Eddie. I just want to say, Eddie, that, well, several generations, I don't know how many generations of students at Wits University who know anything at all about the labor process and trade unions owe that all to you. So I'm really looking forward to hearing what you have to say. Eddie, please go ahead.
Can you hear me?
Yes. Yeah.
Can you hear me and can you see me?
Yes.
Right. Well, thank you very much, Professor Pistor, Katharina, for your persuasive account of how law shapes the distribution of wealth. Lawyers are indeed the keepers of the code of capital, or you sometimes refer to it as masters. I had two very brief questions or observations, comments. I mean, and I'm really coming from this in terms of what we've come to call inequality studies. The first one is really, what about the conventional drivers of inequality? When I think of the drivers of inequality, I mean, I don't think of lawyers, I think of the labor market. I think of the different rewards or the unequal rewards that capital have and what labor has. And I think of the extreme differentials between the senior managers or owners and people who do more routine labor. So I guess it's a question really, is it possible to explain inequality without foregrounding production, accumulation, social classes? I mean, I think, I suppose partly a question, you know, how do you see from a more interdisciplinary perspective, how would you relate to those set of questions? I mean, it's interesting, Piketty in his classic book begins his account with the massacre at Maracana in not too far from us in 2012, and he talks about how that reminds us of the fact that the share of output and profits and wages are at the center of inequality. So it's really a question about how do you see beyond the role of law itself. The second question, which has really been touched on quite often this afternoon, is what are the implications for those of us who are concerned with how to reduce inequality? I think I've learned a new word here, is recode. How do you recode? And what I gather from what you've said and what I've read, you're not a Marxist. You reject the kind of revolutionary path. You're more like Polanyi, the other Karl Polanyi, in the sense that you're arguing for some kind of reform. And you've got this wonderful concept of strategic incrementalism, which I think it's kind of captured in the idea of rolling back. But the question I really was wanting to hear you respond to is how would you, I mean, why would lawyers who are the keepers of the code, why would they want to relinquish their role as the keepers of the code? I came across one review, by the way, of your work, who said you wanted your cake and eat it. you wanted to keep private property, but you also want lawyers to become less completely in the hands of capital. So I guess the question really is, how do you envisage transformation? How would you recode? I mean, you've made some rather intriguing comments about, the idea of cooperatives, worker control, but that's not really driving our law schools. So what forces should we be looking for, in this strategic incrementalism? Thank you.
Okay, well, thank you very much. Great to hear from you, and great for you to see you engaged with my argument. So the first on the labor one thing I should just say, I really wanted to write the book about capital and the transformation of capital over time, the metamorphosis of capital, as Piketty calls it in his own book, without looking at the legal structures. But I had recently had an interesting encounter with a Brazilian historian. They actually put an entire book together in Portuguese, unfortunately, on my book, where they responded. And he was basically saying, as the enclosure movement unfolded, labor relations changed, of course, as well. So you have to look at them in tandem. And I take that point. So I just wanted to focus in on capital, maybe mostly also looking from where we are today, because today, I would argue, you don't need to exploit labor to create capital, right? We don't need labor anymore to create capital. You can create capital out of a win. Financial assets are not labor intensive. They're coding intensive, as are many of the digital assets that we're creating. And so that I just wanted to show that there's social relations, and I think in the production, in sort of during the high times of industrialization, where labor played such an important role, the exploitation of the labor relations were absolute key. But nowadays we can actually do a lot of capital production without labor. And even back then, I just wanted to show that a lot of the work is already done by creating these property rights and using these entity structures, and labor plays a part. But there is a story to be told about the reorganization of labor at the same time to make that project even more successful, without which it could not have succeeded to that point. So this is also the response, I think, to your first question. Don't you have to say something about sort of, the salaries and the salary differential, how much CEOs own, et cetera, et cetera? Yes, I think, in my view, this is basically where I'm coming from, is I think, at least today, this is kind of derivative. The amount of money that CEOs can take home, and the amount of shares that shareholders can buy back is a function of the coding of capital, as I describe it. The decision not to allow labor to participate in these gains, that's a political decision. There's nothing cast in stone, or there's no rocket science behind that. You could distribute this in different ways. I'm in conversation with John Romer at Yale. He wrote a paper on the new socialist firm, still a draft paper. And I said, okay, I'm going to write a paper about it on the governance structure of the new socialist firms. And he basically says, and he uses the Kantian optimization, right? Rather than shareholder value maximization, we do Kantian optimization. So everybody gets back what they contributed in some ways. How you measure that is a big issue. But if you want to go down that way, then you would create a different governance structure, and you would distribute the profits of a firm differently. So yes, I'm more of a reformist. So I'm, the irony of all this, I started my career actually in the 1990s looking at the former socialist world. And I studied Russian. I went to Russia and looked at privatized companies. And I thought at the time that much of what the economists prescribed as recipes were utterly wrong. But I think, and I also don't want to say, I don't want to go back there. It's also a silly argument. There are many different ways of organizing the world. There's not only the Soviet-style socialism and American-style capitalism. We've had a variety of capitalist systems, still have them to some extent. We've had a variety of other socialist systems. So this somehow belongs together. But I think given the ease with which you nowadays can code capital in law, it's just very hard to get people to do anything else, right? When people are saying, why do the American companies not invest? Well, if you can make a ton of money by just repoing it to the central bank overnight, or by doing it in short-term financial transactions, most of the large companies actually are running entire shadow banks at the same time. Why would they invest in anything, right? So I think that has to, just to bring it back down to earth, we have to take that punch ball away. So in my view, it's actually maybe only in the last 20 or 30 years it has become so dominant. But given that it has become so dominant, we have to crack that nut, because there's no reason for shareholders or management to think about labor in any meaningful way unless labor really counts as something, and it counts only if sort of the value of the other stuff is not that easily reproduced. And that, that also, I think, goes into, how to roll back. I think sort of the ease with which you can pick and choose the laws or use your arbiters and still rely on state enforceability no matter where you go. You have to roll this back, because that would actually greatly increase the cost of coding and creating capital in that way, and that would give other voices a stronger leverage, just greater bargaining power in thinking about where we go. You could, of course, say also, well, keep your wealth, and we just do it differently. We just use the state to either, create the money or tax to some extent if it can, and then redistribute in this way. So there are, other voices out there that go down a different path, saying we just do this through money, like Stephanie Kelton's new book that just came out yesterday on the deficit myth, or we do it through taxation. That's Piketty and Zuckman. And I think neither of that is probably fully satisfactory as long as you leave the basic structure, the fundamental structure in place for coding capital. But this is not to say, and I take that point as a critique, because it's not to say that like looking at how labor relations actually were reshaped in this process at the same time, and this breaking down the unions in England at the same time as London really takes off in its sort of new reincarnation as a global financial center in the 1980s, 1990s, is a critical element of that. But given where we are right now, you just won't roll this back or come to a new system by just, I think, recreating unions and strengthening labor rights, because in the big scheme of things, these factors have become relatively less important. Yeah, of course, then you add to this outsourcing of labor, but I think the similar mechanism then would have to apply. But let me stop here. I'm taking maybe too much time.
No, not at all. I don't see any other questions. So I suppose we are at the end of this engagement anyway. At the very least, I think that you've given us being the lawyers who want to see social change, new ways, new fields to excavate, new ways of thinking about what we can do as lawyers, as practitioners and those who teach law and so forth, because you're certainly also raising questions about the content of our curricula, what we're teaching, how we practice law. And for that, we thank you. Your book has made a very important contribution to the South African conversation about inequality. Certainly, we are at what some people call an inflection point. The status quo is just not acceptable. And I think we have a broader ethical commitment to start thinking about ways beyond the kind of system we're living in. So thank you again for your presentation, and we look forward to an ongoing relationship with you and perhaps with your center.
Thank you very so much. Yeah. Well, yeah. Thank you. I mean, it was really a pleasure, and thanks for inviting me to give this seminar. Thanks for your interest in my work. Of course, that's the greatest thing that you can tell an author, that it has an impact. People are thinking about it, and part of that, of course, is also the critique. I mean, one voice in my, it's actually the first time that I've written so intensively an entire book just on the Western capitalist system. It's mostly about the West, not entirely, but there is, of course, a perspective from the global South that I'd like to at least pursue in conversations and engagements like this one. So I really appreciate the opportunity to speaking to you today. So thank you for having me.
It was a pleasure. Let me just also thank Kathy and Eddie. We've started our research and seminar project with a bang, I think. And thanks to all of who you have participated and contributed. So thank you very much. Look forward to continuing this conversation.
Bye. Take
Bye.
care. Bye-bye. Bye.
Thank you. That was absolutely
Bye.
wonderful.
Thank you and bye.
Thank you. Bye.
Bye, everyone. Thank you.
Bye. Thank you.
Bye. We'll talk soon. Thank you, Rose.
Pleasure. Bye. Bye, everyone.